Thank you, Commissioner. To address just a couple of things. First thing I was going to say is address what is and what is not before the Commission, and I can drop that because I can just incorporate by reference your opening comments taken from the EFSB order, pages 15 and 16, about what's before the Commission, the need for the proposed facility, whether it's cost justified, and whether efficiency can be an alternative. The EFSB order set that out, and in that regard, I'd like to move to strike section 1.5 of Ryan Hardy's April 22nd pre-file testimony that is, as he says, looking at environmental impacts, especially carbon emissions and climate. CLF believes that that's a very, very important issue. It will be addressed in the EFSB. The scheduling conference council were told that there's going to be a separate day at the EFSB addressing that. But as you noted earlier, that's not before the PUC, and the testimony isn't proper here. Similarly, Mr. Hardy's testimony, section 1.6, starting on page 23, line 7, addresses the purported economic impact of the project on the economy of the state of Rhode Island. Again, beyond the purview of what the PUC is considering in this hearing, I'd like to move to strike that. I'd like to address for a moment what CLF will endeavor to show with our witnesses tomorrow. We're often asked, CLF is asked, you know, you're an environmental organization, we understand you're concerned about carbon emissions and climate and the environment. Why are you litigating in the PUC when the question before the PUC, or the questions, is the need for the project and the ratepayer impacts? And the answer is very simple. Invenergy has told the public, has told the community, that the plant is desperately needed, as Mr. Shore said, to keep the lights on for system reliability, and that there are going to be huge, huge ratepayer savings and benefits from the plant. If that were true, which CLF believes it is not, but if that were true, I think it would be very difficult for the EFSB to refuse to permit the plant regardless of what the carbon and environmental impacts may or may not be. CLF is litigating here in the PUC in order to show, one, that the plant is not needed for system reliability, that it is simply not accurate to interpret the ISO's auction results as being, if a plant clears, if a plant gets a capacity supply obligation, by definition it is needed. And second, that the ratepayer benefits that Invenergy has claimed are greatly exaggerated. That the division's witness, Mr. Parker, was much closer to the mark when he said that the ratepayer impacts would be, quote, small but meaningful, unquote. CLF wants later to go to the EFSB and say to the EFSB, the plant is not needed for system reliability. There will be small ratepayer benefits, and those small ratepayer benefits need to be balanced against the carbon emissions and environmental harm. That's why we're here. That's what we'll endeavor to show. The final thing I want to address, Mr. Shore spoke about prior rulings of the PUC, the Indet case, Tibberton Power case, the Hope Energy case. And Mr. Shore argues that those three cases stand for the proposition that the PUC ought to apply at the base standard of need, that everything changed in 1996 with restructuring, and that now you can apply a new debased standard of whether the plant is needed or not. I would respectfully suggest that all three of those cases stand for the same proposition, because the same three things occurred in every one of those cases. In every one of those three cases, there was dictum by the PUC to the effect that restructuring in 1996 should change the basis, change the standard by which the PUC evaluates need. The second thing that occurred in every one of those cases is that the PUC ruled that until and unless the Energy Facility Siting Act, the underlying statute, was changed, the PUC was legally obligated to apply the old existing standard. And third, in every one of those cases, the PUC did apply the statutory requirement from the Energy Facility Siting Act. In all three cases, there was dictum that said, oh, this doesn't seem to make sense. In all three cases, the PUC said, but the law is the law. And in all three cases, the PUC applied the law. In this case, we have a rather unusual situation. If you look at Mr. Parker's testimony on page 24, he's asked at line 5, what statutory criterion did the EFSB direct the PUC to address concerning CREC's cost of capacity and energy? And Mr. Parker answers at line 7, quoting the statute. EFSB defined issue 2 on page 9, quote, is the proposed facility cost justified and can it be expected to produce energy at the lowest reasonable cost to the consumer, unquote. Mr. Parker says this criterion is taken from the statute. Next question at line 14 is this. Is the cost justified criterion appropriate in New England's deregulated and competitive generation market? Answer at line 16, no, it is not justified. You've got an expert witness who's not a lawyer, didn't go to law school, telling the PUC that in his opinion, the law is silly and you should not follow the law. But in Indet, in Tibberton Power, and in Hope Energy, in all three cases, despite the dictum to the contrary, the PUC held that the law is the law, and the PUC followed the law in all of those cases. Thank you.